Good afternoon to you. We will continue with the Constitution. We have started Election Commission. We have seen the introductory part. We have seen Section 11 of Representation of People Act 1951, under which the Election Commission has powers to remove or reduce the disqualification attached to a conviction. With the orders of Election Commission, Mr. Tamang became eligible to contest a by-election and retained his chief ministership. Normally, the powers given in Section 11 should be rarely used by the Election Commission and seldom used in case relating to a conviction for corruption. The disqualification from contest is a civil disability created by the electoral law with the intention to keep those convicted by the criminal offences from entering into elected offices. That was the intention. Nevertheless, the argument of Mr. Tamang was, as I told you in the last class, that the law prevailing at the time of commission of the offence entailed disqualification from contesting election only if the imprisonment was for a term of 2 years or more. So, according to him, the amendment made in 2003 cannot apply to his case, which happened much earlier. Commission of the offence is in 96-97. So, you cannot apply a law, a criminal law, retrospectively. That is his argument. From the examination point of view, it is enough if we know the purpose of Section 11. Who has the powers and in which case it was recently used. Up to this, you should know. Now, the Election Commission has the powers to cancel the polls in the event of rigging, booth capturing, violence, and other electoral malpractices. Election Commission can request the President or the Governor for the services of the staff necessary for conducting the elections, to supervise the machinery of election throughout the country is also the primary responsibility of the Election Commission headed by Chief Election Commissioner. Most importantly, the Commission has to advise the President whether the elections can be held in a state which is under President's rule, in order to extend the period of President rule under Article 356 after 1 year. The amendment was made through 44th Amendment Act 1978. By this amendment alone, the Election Commission acquired the importance in the Constitution. Prior to that, Election Commission was not having so much importance. 44th Amendment Act made it mandatory. If the President rule is imposed in a state and that President rule is proposed to be extended beyond 1 year, then the Election Commission should certify that it is not conducive for the Election Commission to hold the election. So, now the Election Commission has come into the picture under Article 356. So, this is the way in which the Election Commission acquired importance through 44th Amendment Act 1978. And remember, Model Code of Conduct brought into force in 1967 after the political parties unanimously agreed to the contents of the code. For example, Ministers should not sanction any developmental projects or grant financial assistance from their discretionary fund when the election was announced. The Code of Conduct was issued by the Election Commission in 1991. The Code of Conduct has prescribed broad guidelines, especially on the following: no party or no candidate shall create tension between different castes, different communities, different religious groups, or different linguistic groups. The parties should refrain from criticizing the other political parties on personal matters. They should confine only to the policy and programs, past record, past work, and aspects of private life should never be touched. If a recognized political party violates Model Code of Conduct, the Election Commission is within its competence to withdraw the recognition of the political party. It should be noted that the code has not been given any statutory status. Instead, it is only voluntary agreement, consensus among the political parties to ensure level playing field. PT point important. Again I repeat, it should be noted, remember, the code has not been given any statutory status. It has no support of law and it is only voluntary. PT point of view important. The Model Code of Conduct is announced much time before the election notification is issued. Normally, election notification is issued 2 weeks before the campaigning period. But normally what happens is the Model Code of Conduct already will be issued much in advance. For instance, now Bihar elections are at a later period. Now the Model Code of Conduct has been put into effect right from day before yesterday. The moment they announced the Model Code of Conduct has come into play. So the critics of the Model Code of Conduct believe that the Code of Conduct which comes into effect much before the notification obstructs, prevents the government's initiative for a very long time, because government cannot announce any developmental projects, any plans. So naturally, all the development projects are stuck. Suppose in our country, if you see the 1 year, some state will go for by-election or general election. And in fact, in 2 years there was 3 general elections. So that is possible. So as and when there is an election, the notification is issued, the Model Code of Conduct will come into play much before. So naturally, the government is handicapped. The government has to reform the electoral system in a number of ways. They have undertaken a lot of initiatives, you have to admit. What were the initiatives taken? Voting age was reduced from 21 to 18 by amending Article 326. Voter identity card was introduced and so also electronic voting machine. Election Commission was made a multi-member body with 1 Chief Election Commissioner and 2 Election Commissioners as provided in Article 324, which we have seen in detail. There was a limited introduction of what is known as state funding of elections. No candidate can contest to Lok Sabha from more than 2 constituencies. Delimitation of constituency for Lok Sabha assemblies on the basis of 2001 census. Section 8 of the Representation of People Act 1951 has been interpreted in such a way to debar the convicted persons from contesting even while an appeal is pending with the Supreme Court. This case is very important from the examination point of view. Means, I told you section 11 and section 8.4 is very important. Section 8.4 is important because remember previously what used to happen is when an MP or MLA is disqualified by an order of the High Court or Supreme Court, he will be given time for 3 months so that to enable him to prefer an appeal. And once his appeal is admitted, he can continue to be the MP or MLA. So that appeal will be decided after so many years, after 3 years, 4 years. There are many ministers and who were minister in UPA 1 and UPA 2 whose election petition is still pending. So they will continue in spite of the fact that the trial court has convicted them. They just prefer an appeal within 3 months and they will continue to hold the post. The argument of the government is that it is a coalition era. Even 2 members or 2 ministers can topple the government. So if the moment if the person is disqualified and if he loses the seat, naturally the government of the day will be in problem. So it is not proper. To ensure stability of the government, they were allowed to continue. That was the argument of the government. But in Lilly Thomas versus Union of India, Supreme Court in a writ of public interest litigation held subsection 4 of section 8 of RPA 1951 is violative of Article 14. Remember, section 8 within bracket 4, subsection 4 of section 8 of RPA 1951 is violative of Article 14. Under Article 103 and 192, the seat of the member of the House who has incurred disqualification becomes vacant on the day he incurs disqualification and cannot wait the decision of President or the Governor as the case may be. It is the filling of the seat after falling vacant which avoids decision of President or Governor under the subsection 1, 2 and 3 of section 8 of RPA 51. The disqualification will not operate from the day of the order of state or the conviction passed by the appellate court under section 389 of CRPC. The section 8.4, subsection 4 of section 8 of RPA is a saving clause which defines the date of disqualification where the appeal filed within a period of 3 months by sitting members of the Parliament or state legislature are still pending. This was the position. But the Supreme Court held, remember, Supreme Court held section 8.4 of RPA 1951 is violative of Article 14 and ultra vires to the Constitution. Nevertheless, the judgment was declared to be prospective effect. Otherwise, it should be against the natural justice. If you make it retrospective, then many MPs, many MLAs should have been disqualified. Fortunately, Supreme Court applied the prospective overruling. So, like what they did in what is known as Golaknath case, they applied prospective overruling and saved the past disqualifications. So, they did it because the sitting members of Parliament legislature would have the knowledge of judgment from the date of their pronouncement. So, Election Commission has so much power. Section 8 and Section 11 both are very important from the examination point of view. Then, Election Commission has a vision and principles in a strategic plan of 2016 and 2025. Between this period, there is a vision. What is the vision? To become an institution of excellence. What is its mission? To maintain independence, integrity, autonomy, and also to ensure accessibility, inclusiveness, and adopt the highest standards of professionalism. This is the Election Commission's vision and the what is known as strategic plan for the period of 2016-2025. Rest of the things we will see in the next class. Thank you.